Supplementary cost list, item number 1.
My lord, the present application is filed by 86 applicants are here. Initially, initially 90 of them filed the writ petition, and during the pendency of this writ petition, 3 withdrawn without any condition, and another 26 of them filed application for withdrawal, striking out their name, with the liberty to file afresh with regard to ROW. But my lord, the lordship did not incline to entertain that application and allow them to withdraw with the liberty to file afresh, and they did not file a fresh application for withdrawal because their right is confined to, they want to protect the ROW. Now, as of now, out of 90, 3 withdrawn already, and last Friday, one applicant, Mr. Matthew, moved the application where my lord has passed some protection order there, and now 86 of them has filed this application. My lord, lordship is very much aware.
How many writ petitioners are remaining now?
Now, my lord, 87.
87 filed application.
Yes, 1 person.
For 1 person.
Yeah, 1 person. Lordship has given protection.
Now there are 86.
Now
86 are here.
86 are here. And out of 86 here, as admittedly, some of them has received compensation with regard to outside the ROW, but they are still remain a party. And now what happened till yesterday, Saturday and yesterday evening, the JCP deployed by the collector.
So if they are not similarly situated, can the same thing, see, the other day what was pointed by you was that there was an interim order.
Yes.
Case number 188.
Madam, I have an same interim order here.
Oh, yeah, here.
Madam.
Yes.
That one, Lordship, can you see page number? Page 30. 2021 Lordship is referring to. Yes.
You pointed out the paragraph 5.
My lord may come to page 31.
Yes.
At the bottom paragraph 5.
Yes.
I have heard the learned counsel for the parties and given my thoughtful consideration to the matter. I have also seen the order dates and such passed by this court, which has rejected the prayer of the petitioners who prayed for suspension of the notification and for further construction pending settlement of compensation. As the prayer for suspension at that point of time has already been rejected, the petitioner should abide with the order of this court and not cause disturbances and allow the project to continue as the same is in public interest. Furthermore, as stated in the affidavit, the process of compensation is still not complete, and it is must be given a chance to be heard and present their case as and when they are called upon by the district collector. Now, this application is according to this of with the direction the district administration within the shortest possible time shall facilitate the handing over ROW to the NIGTCR, and the petition should not cause any obstruction. It is expected further that the records of the land as directed by the orders and such shall be maintained by the courts. This order, my lord, passed in 2021, December.
Now, basing on this, what was argued by you was that there should have been an opportunity of hearing before they were directed to move out the
that is order of this court.
And then the payment of compensation.
So what the learned single bench was emphasizing is that give them opportunity, then pay them compensation. In the meantime, if you proceed for the construction, you proceed. Petition should not obstruct it. Now, this was 2021 position. 22, they didn't take any steps. 23, they didn't take any steps. And the matter came up before my lord. We argued the case, and lordship went express as to why my lord, this honorable cannot set aside or intervene, quash the proceedings in view of the violation of Article Section 15. My friend took time to ascertain the number of the person who received compensations. In the meantime, my lord, I believe that my friend is not instrumental in this, but the collector, the man in which he is proceeding. But the parties are even filing.
Was the order passed by this court the other day?
We have next.
Well, there's another matter pending before
Other court, my lord.
Yes, court number 1.
That is page number 38. 38.
Yes, and that case is likely to come up.
It is coming up tomorrow.
No.
Page number 38 of my application. Para 4-5 when we read.
Are you dispossessed already?
My lord, what happened? We have prepared this miss case. Miss case, my lord.
Yes.
Saturday. Yesterday evening, my lord, I received instruction that the JCP continued the demolition drive continue unabated, and then applicant's land has been touched. Trees has been fallen down, shop has been
We'll have
demolished.
this matter day after tomorrow.
Yes, till then, my lordship, I give an immediate
At least with
Stay on.
respect to the applicants whose land has already been not touched.
Instructions. As far as this particular stretch is concerned, there are no structures standing as on today, barring the stay orders in respect of the applicants who have been protected by your lordship's orders.
That
Those
is
will be
only in respect of one person.
Two, Matthew M. Sangma, which lordships were pleased to take up on Friday, and Victrola Sangma, which Justice Thank You has passed an order in respect of. So these are the only two litigants in respect of whom there are some protection orders.
You see, we'll pass an order of status quo.
In respect of
Status quo as in today.
lordship. So kindly see one thing, my lord.
Yes.
They will continue to demolish.
Mr. Sen, the
Demolition
problem
will
is that
continue.
It is very difficult for this court to determine what is the factual.
My lord.
Only thing is that if you see, like it was expected that the people will be paid
Lordship.
the amount of compensation before they were removed from it. If it is done, well and fine. If it is not done, then I think that
No, I have instructions insofar as that is concerned as well. My lord. So there are two issues here. One is land which is outside ROW, and one is land which is inside ROW. Their agitation in these cases is only in respect of the ROW.
Then which way we decide what is ROW and what is outside ROW?
Yes, no
There has
survey,
been a survey, my lord. So they are
no demarcation.
no
demarcation.
Their entire writ petition here is only in respect of the ROW. I can take your lordships through their prayer as well. Their entire prayer, their entire objection, the original objection which was filed in 2019 as against the Section 11 application, the Section 11 notification also relates and is confined only to the ROW, nothing more. That's why the issue is only with regard to the ROW right now.
See, ROW,
My lord.
how come there is Section 11
Yes.
notification with regard to ROW? ROW is something.
No, my lords, ROW was excluded. So there exclude that area falling under the ROW. And they say this stems from
Wait,
the
one second. This is a construction of a new road or the widening
of an existing road.
So it means, say supposing for widening,
Lordship.
until and unless you are required to go beyond ROW, you do not have to acquire fresh land, isn't it?
Correct. So that is that 35 feet from the center of the highway.
So it seems that your widening of road would be beyond that.
Within the 35 feet.
Within
Which
the
is
35
part of
feet.
lordship.
35.
So
That means the ROW also will get extended.
that is for a subsequent situation where they want to increase the ROW. Their acquisition proceedings may be necessary.
See, for layman's understanding,
My
say
lord.
supposing you have supposing today if you have a road, a constructed road, already constructed road of say 30 feet, or may I say 50 feet. Okay, so apart from that 50 feet on the both sides, you will have ROW.
Yes.
Now you decide to extend that road, the width of the road from 50 feet to 80 feet.
Lordship.
So definitely the ROW which was there, that will become a part of this road.
Correct.
Now whether again ROW will get extended from that.
So that I don't have that instruction.
If it is there,
right now.
and if that extension falls in a private land, then it's a fresh acquisition.
No, so that's what I'm trying to distinguish, my lord. The state is not denying any payment in respect of areas which are outside the ROW. So let's say this is the highway right now, and this is 35 feet from the
That is
center.
one thing. You see, one difficult thing to understand. You see, falling outside ROW. Now, what would be ROW? On what basis it will be seen?
On the basis of the patta, my lords, 35 feet from the center of the highway on both sides.
That is all right.
So the
But then
patta,
how
one of
much,
the
how
conditions.
much load? See, the fact remains an admitted thing that you have acquired some land for the purpose of widening of the road.
Yes,
Not a fresh construction, isn't it?
correct.
Now even your ROW, if you say it is a fresh acquisition, within that acquired portion, it cannot be beyond acquisition. Say supposing if a person has already a property standing in one arena, and you decide to construct or rather widen a road which was passing through by the property, by the side of the property at a later stage. Just because you widen the road, does it mean that his private land will automatically become a part of the?
No, that is
No,
not what we're saying. We're not saying that, Balur. What we are saying is, as on today, this is the width of the road. Let's say it's 10 feet. And the stipulation in their patta is 35 feet from the center of the highway will not be part of their private lands. So insofar as that area is concerned, the 35 feet from the center of the highway, we are not giving them any compensation. For acquisition beyond that, they are entitled to compensation, which is why several of these landowners have already been paid compensation. So it is incorrect to say that we are not paying compensation. I have taken instructions.
But then it is only with regard to the measurement of the land, how this High Court will do this.
That is what we are saying, Lords. And
then definitely then there is a what is the new provision of the section 30 of the old act? What is the new thing?
Apportionment 76.
76. So that will come under that only.
It's a question of, exactly, that is where the question of title will come in. So if there is a dispute with regard to title or measurement, they'll have to be referred under 64 or 76. That's all. And now they have themselves conceded this point by preferring a division bench, by preferring a writ petition before the honorable division bench, challenging the wires of the GHDC statutes.
That is a different issue. You see, even if it is challenged, if it is allowed or not allowed, will not have any bearing here, because the question would remain, that is with regard to the measurement of the land.
Lordship. So because we have excluded
whether they should get compensation for how much land, that will be the prime issue.
Yes.
See, and now if they are getting for 20 feet,
Lordship,
after that ROW,
Lordship,
it may become 30 feet.
Yes. Correct.
Isn't it?
Yes.
So that is what. So this is only the thing. So how a writ petition will decide?
So on the last occasion, Lordship, I said the same thing, that it is not that they don't have a remedy. The remedy lies under 64 or 76, whatever the case may be.
See, the question is not that they don't have a remedy. Just because there is alternative remedy, that will not deter until and unless like the violation of CS. Now here the thing is that here it means like it concerns the area of the land, nothing else.
Lordship, and let me also specify something else, something which was raised consistently. Against the Section 11 preliminary notification, they filed an objection. That objection only pertained to the valuation and the exclusion of that ROW. That is why I can take your Lordship to that objection. Section 15 objections were heard. A Section 19 declaration was published, which categorically said that hearings were conducted insofar as the persons interested in the lands. That entire hearing has been done. Awards have been prepared. Several parties who are entitled, they've already come and withdrawn the amount. These are the people who don't want to withdraw.
But that is all right. They may have, just because several persons have withdrawn.
No,
that will not bind them.
Senior had said that money is not being paid.
What we are concerned about is that what is the problem. See, this court was basically all along unable to get. It's like whether that is concerning only that, you see, like what is the right of way, ROW, yes, or it is something beyond that.
Whatever is beyond, we are paying them.
The court was under impression that is acquisition of land, some part of land without payment of compensation. Now that is why this writ petition has been. But then if it is only with regard to area,
Lordship,
that you are not paying anything. If their claim is that you are not paying for ROW,
Lordship,
and they have an entitlement to claim for ROW, you see, that can be decided even by the referee court.
Precisely.
There is no question that writ petition court will decide.
Precisely.
Because it is basically a claim for extended land,
yes,
extended area. So whether that is legally attainable or not, that is attainable or not, that is, let the court that below decide.
Precisely. That's what it is.
So what remains then?
The GHDC is saying that they are not entitled. So we are saying they are not entitled. If at all they are entitled, the special court will look at it.
Court is not. Now we are going to decide it. You see, Lordship, because this is about these things. Lordship. So that is why, see, what this court at the this point, as mine is that we maintain status quo till day after tomorrow.
My lord. Status quo. This is the instruction that I have, that whatever acquisition proceeding was insofar as the ROW is concerned and the removing of structures, that is already complete. The only areas they have not touched is in respect of two of the petitioners who already have orders from this court. Now also see, your lordships, there are 86 people which are before your lordships today, which are part of these cases. Now of them, we were just going through, we didn't have enough time. Kindly see number 12, petitioner number 12. I think it has been filed in some hurry. So there has been some mismatch insofar as the name of the parties are concerned.
Yes.
At page 3,
yes,
petitioner number 12, this petition number 12 does not exist.
It's still the M7
Already
order.
been substituted by an order of this court dated 4/8/22. Now, how will your lordships pass these orders?
That is a
Becomes very difficult for us.
My lord.
That is a problem, you see. On the other day also, this is just because of that issue of one applicant and applicants. Unnecessary things become complicated.
My lord, but with due respect, my lord, with due respect, if lordship, other side has a reservation on number 12, it become very quite technical. We could have replaced it. But the admitted fact, my lord, other bench has passed the order and lordship has also passed the order. And see the conduct of the collector.
There is a change of situation.
My lord, therefore, my humble submission is the conduct of the collector. A collector refused to face the final hearing of this matter, and behind the back of this honorable court, deploy the eviction drive. And when lordship sees the matter now, ready to hear it, my friend is saying that operation has been done. We don't believe this, my lord. Why let them file a detailed affidavit day after tomorrow, whatever, along with the records. Let them show. Well, if they say that all operation has been done,
This demolition drive has been completed.
no, my lord, my instruction till yesterday evening is that till 9,
Mr. Shangresh,
land of the 9 people
we do not
has
want
been
to
received.
create any trouble by passing an interim order at the stage when the entire thing is over. See, because this will be
No, it is not over. But if it is over, what is the point of filing this application? If the operation is done,
We'll order status quo.
but we will not file this application.
We are not going to
This is
complicate.
absolutely
Things
my
will
lord.
become, you see, like unnecessary, it will complicate the things.
My lord, if I only
do not
cite,
know, you see, until and unless the clear fact is placed before us.
my lord, therefore, my lord, therefore, let them place the detailed facts. Till then, my lord, lordship may stay the notice. Like other Matthew case and other matters.
We'll just say we'll maintain status quo.
My lord, the status quo, what they will do, with due respect, I don't interfere with my friend.
Order only in respect of the petitioner which was before the court.
That is
Kindly
true.
see the affidavit for a
That is
moment.
true. Here also the same thing.
Shen, this order was passed,
Lordship.
being prosecuted by the previous order, where is the impression created that you see they were ousted without pay.
No, my lord. I'll take
Exactly.
the order. I don't know what has been
So
projected
that is
before
why
this
the
court.
precisely inquiry of the court was that whether those people are sought to be dispossessed without any payment or not.
No, my lord. That's absolutely incorrect. That is not
And
what
my
happened.
friend
Supposed
has
to-
said-
This court has passed this order on Thursday,
Li-
say that there is no evidence of payment before this court
Yes, yes.
at that moment of time,
Lordship.
and also the fact that the other court had given some relief to them.
Lordship.
Yes,
I'll
yes.
just point out the reason why this had happened. Kindly see page 38, the order which has been passed by court number 2 on the 31st.
Yes,
Kindly see para 2 onwards.
yes.
By the present writ petition, the writ petitioner has assailed a notice dated 15/7/24, which has been issued by the DC West Garo Hills, Tura, asking persons in the stretch of land so and so to so and so to vacate such land or structures by 31/7/24 as the construction of the said highway. It has been submitted by the learned senior counsel for the petitioner that the writ petitioner herein is in possession of 14 meters running length alongside the road, my lord. And the grievance is that without due process of law or proper acquisition proceeding, the notice has been served upon her. It has been further submitted that the writ petition has never been heard by the collector, though there are orders from this court directing that all concerned persons be heard before any action is taken for handing over of the right of way to NHIDCL. She therefore prays that as far as the petition is concerned, the impugned notice be kept in abeyance. The learned GA appearing for response number 1 to 3 has however submitted that due process has been carried out inasmuch as declaration under section 19 has already been issued, and further that the same subject matter is pending before the division bench of the court. He therefore submits that no interim orders are called for at
That
this
is
stage.
pending before a division bench of this court also.
No, that
But then on the other day you submitted that it has no connection. This is
Exactly,
no
both
connection.
of
no,
them.
not that.
Both of
I'll
them.
point out why. They were referring to the ROW. Kindly see para 3. They were talking about the ROW. ROW has been
My lord, I
excluded.
fail to understand.
Which is why we pointed out to the court that the issue of whether they have any entitlement to ROW or not, one issue in respect of the same petitioner, Matthew M. Sangma, is pending before the division bench.
How do we get to this only?
Now-
How do we get to this only concerning ROW?
In the division bench, I can file an affidavit, Manoj.
No.
Bring that on record.
This case. This
Yes, I'm
order-
just coming to that. This is their submission, Manoj. Kindly see para 3.
Yes,
It
yes.
is the submission of the petitioner that the land is 14 meters length, running alongside the road.
Yes. So
Therefore,
that-
it was the ROW.
But
Number
then-
2,
see,
they said,
running alongside that means it can be a land beyond ROW also.
correct. So, we had informed the court that if it is only limited to ROW, there is no question of any entitlement. Number 2, their case here was that against the Section 11 preliminary notification, they had filed an objection. And that objection was never heard.
You see, there cannot be any claim for ROW. Because ROW is excluded.
Yes, yes.
is it? So it means if you say that somebody has a land running along with the road,
Lordship.
that means beyond ROW.
No, not necessarily, my lord. If this is the highway, the tar highway, 35 feet will extend beyond the highway as well.
See, once you see, please try to understand. If somebody says, here this submission was that petition was in possession of 14 meters running land
Running lane
along there.
alongside the highway.
Yes.
So it would include
that
part of the
means
ROW as
that
well.
lane can only relate to the land which is beyond that ROW.
No, that's not what we were saying, my lords. Their case was not just that.
That is
was,
your counter. That is your counter.
Lordship. Anyway, so
But
that's on facts.
Otherwise, if somebody says that he has a running land along the roadside,
Lordship.
it doesn't mean that it is only the ROW. It means can be something beyond that.
It could be, but it would also include ROW. That is our case. Anyway, that's a different issue, my lord.
It will,
But-
see, if you say, then it is assumption is that if you say that the provision of that act by which the person is supposed to not make any claim
My lordship.
with regard to ROW, that means this ROW basically is outside the private.
It's outside the private land,
Yes.
exactly. It's outside the private land.
It is not that the state will have to rely on their mercy for leaving that land.
Correct.
It's okay.
Yes.
You have a rightful claim over there.
Yes.
Because
yes.
this is by virtue of a legislation by isn't it?
Lordship.
So definitely that 14 meters where it is been projected in paragraph 3 here, it cannot be in relation to ROW.
That is the instruction that we had.
dispute it by bringing it,
My lord.
but then that question how a writ court will dispute.
Fair enough, my lord. I'm not going into that issue. I'm also saying that their case here in the writ petition as pleaded by them was that against the section 11 notification they filed certain objections and that they were never heard. No hearing under section 15 was done, and in fact they had not even disclosed the fact that the section 19 declaration had already been published by the collector. So we pointed out to the court that in respect of the same stretch of land and in respect of the same project, a section 19 declaration had already been published.
So
which lordships will find?
This publication of section 19 declaration,
My lord.
it was before filing of the writ petition before this court also.
No. In this case, the section 19 declaration was already published. They brought that on record. They're also challenging it.
So there is no suppression there.
Yes, my lord. So now, interestingly, against the section 11 notification, this particular petitioner, who was before court number 2, Victrola Sangma, had signed Matthew M. Sangma. And this objection was filed on 5th September 2019 against the section 11 notification. After that, the objections were heard. Some of them participated, some of them did not participate. But in any case, a section 19 declaration was published. So therefore, the hearing for that stage of section 15 was already completed. Now, this was not disclosed by them in the writ petition before court number 2.
See, wait. That when this order in the miscellaneous declaration number 188 was passed,
Hello.
the order which is at page 30.
Lordship.
This order was passed in 2021.
That time the section 19 was already there.
So then what was the hearing for? The order.
They wanted to stay on the entire proceeding.
No, but then this direction passed here.
Lordship. And is expected that the petitioners be given a chance to be heard.
Yes.
And present their case. This is with regard to the hearing under section 21. 21.
That is for
Compensation.
Compensation. The
Yes,
rate of
sir.
compensation.
Yes, that's all. The section 15 hearing is already complete. That is very clear from their own writ petition in the section 19 declaration. It clearly says that the section 15 hearing is complete.
Mr. Sangaresh, when this writ petition, main writ petition is coming up?
Madam, day after tomorrow morning. The affidavit filed by the collector did not make any statement that the section 15 has been adhered to.
No, but then it's a matter of.
Therefore, the submission of my learned friend.
Are you denying that?
Yes, madam. That was the primary.
No, but then
ROW.
Section 19 has been published. It is deemed. Once section 19
No,
is
madam.
published.
But I will show Supreme Court judgments where the collector proceeds to issue section 11 and 19 without adhering to 15. This Honorable Court can quash the entire proceedings. I'll show on day after tomorrow. And the affidavit filed by the collector, admittedly, on record, in my paragraph 2, non-adherence to section
So,
15,
you want
he
to
admitted that he did not.
Okay.
He did not hear. And my friend, second, he
No, but
pointed
in
out.
section 19, it was held quite some time back.
8/6/2020.
My lord, section 19 was issued, and within
And
less
then
than
you
2.
filed that miscase thereafter, that 188.
My lord.
Yes.
Therefore, this Honorable
So
Court
it was
refused.
not stayed. The proceeding was not stayed.
My lord.
So once have you challenged that order?
My lord, it is not. It is a
No, no,
conditional order. It is bought
No,
for
then
good
no,
for both the
then-
parties. I'll satisfy my lord. Now,
mean,
once
we'll-
my lord,
We
nature
will
submits.
We will have it after tomorrow. We'll pass still then status quo.
My lord, I'll
Only-
pray,
only
my
that
lord.
much,
I'll
nothing-
pray.
nothing.
Now, my
Lord,
friend has
just
pointed out
for,
section 21. Now, section 21, he did not issue even section. The lordship has seen the 2021 order. Right to be heard. Apology should be given to the parties for compensation. Now, what he can do on the collector, he has to issue section 21 notice to all the parties in heard. Admittedly, he did not issue any section 21. He
Anyway,
did not
Mr.
go
Sandesh,
for, instead he issued this eviction order. Therefore, other court, and this
the
court has
problem
passed
is
that
that
order.
you see, problem is this that some development have taken place. in
My lord,
between.
therefore, if any, my lord, if the collector has done some of the land, my lord, that is done already. But the remaining one, they have no right to touch further, my lord. My lord, assist the matter.
That is why status quo. That is why status quo.
That's why I reserve for that, my lord. My lord, with due respect, my lord, profound,
See,
profound
The thing is
respect.
that if we pass any stay order at this stage, this may bring more complications.
Oh, my lord, the reason why my
Because
lord,
you yourself has admitted that you see some action has been taken
No.
during the last 2 days. So that is
no, therefore, my lord, these are 10 petitioners, 10 applicants. Remaining, my lord, lordship may make it very clear.
We'll have it. We'll order status quo.
And my lord,
Lord,
just for
lordship,
my
the
satisfaction,
reason
I
why,
just point out
the
one
reason
thing.
why I have a reservation
Just a matter of
for
form.
status quo is this.
Your lordships
My
have
lord,
seen.
My lord,
I've-
I request, my lord, see the conduct of the parties here. My lord, if lordship pass a normal stay order, status quo order, we have no grievances. But see the conduct of the collector here, who faced my lord with full face in the last occasion, sought time for ascertaining to who are the recipient of the compensation in informed way. They sought time 2 times. With bona fide impression, my lord, I did not oppose also.
But then that
Since the officer of the court.
that would
Now,
that
behind the
that
court,
was-
behind this court, he has resorted to this
See,
method.
See, Mr. Sangresho, asking information about the person, those who were, and proceeding with the proceeding things
But-
are
but-
two different things.
My
Doesn't
lord,
mean,
they are not, even now, they are
doesn't
not
mean-
disclosing.
Now, if you want to say
But-
that yes, they have ousted somebody who has not received compensation, then definitely we will take
My
it
lord, they are not
seriously.
coming up. My lord, that issue,
Otherwise,
they are not coming
otherwise
up.
you do not take it serious violation of the
My lord, they are not coming up. That he has received already, only 30 are remain. In that case, lordship may kindly consider only with regard to 30.
Refusable on what ground that is has to be seen. Whether you are, it is because of your conduct or because of them. That is the main.
But where is my conduct? That is attract for,
No, if
my
that
lord.
money is ready and all,
But-
if you are
but
not,
I do
refusing,
consider even
you are
now
not
also.
going and
My lord, even lordship may record. Even if lordship other side reservation, lordship will stay the order, eviction order, with regard to those writ petitioner or applicant who did not yet receive the compensation. It may not go for those who have received compensation.
Received compensation for what reason? That is what is to be.
My lord,
see,
therefore, the conduct, if lordship pointed out the conduct of the parties, that when you are approaching before this court
we are
and
giving
receive,
status quo. At least,
my lord, the
that
status
is-
quo,
that
my
is
lord,
what-
the collector will continue to manipulate. He has
No,
DCPs.
you have to have something.
No, my lord. Lordship, kindly hear
You
me.
see,
My lord.
the thing has become. You see,
Friday,
this
Friday,
court-
Saturday, Sunday,
It
he
is
deployed
very-
5 GCPs, my lord,
That is
mowing down all the shops and the trees, my lord. The status quo
see,
order, it will be a privilege for
a
him
submission
to
has
continue.
a submission has come from London.
But there is nothing on record. Therefore, see the conduct of the parties, my lord.
See,
My lord. The other courtroom, my lord, my friend said that the entire matter is sitting by the division bench, where in this case, my lord, my friend and others, CJC, strongly resisted. They should be disposed of immediately. Nothing to do with the division bench matter. What is going on, my lord?
that is of
And
course
the
one thing we
citizens-
do not know, Mr. Sen. This is one part that you assisted here.
Exactly.
The adjournment of matter on the ground that it has no connection with the pendency and division
No,
bench.
it really does not, my lord.
And then in the other court on the same subject
No,
matter, you have
a
made
question
a
was
submission.
asked. I'll explain why, my lord. Because Victrola Sangma was a signatory to an objection along with Matthew M. Sangma.
That is
So in that context, I
Who is-
explained to the court,
Who is Victoria Sangma?
the petitioner before court number 2. She had signed the objection to the Section 11 application along with Matthew M. Sangma, who has filed the applicant the writ petition before the division bench. In that context, I explained to the court, Matthew M. Sangma, who's one of the objectors, has filed an application to the court. I did not tell the court that this is connected or has any bearing at all. It was only on the question of ROW. Questions were coming, so I had to explain to the court that the ROW issue is pending before the division.
One thing we do not understand, why because of the pendency before division bench, this single bench proceeding should be stayed.
I'm not asking
Even
to
even
stay.
even
Lordship.
even even it is. Say supposing,
Lordship.
see, the admitted thing is that the challenge to that part of ROW before the division bench has been made after the initiation of land acquisition proceeding.
Yes,
on
yes,
those-
exactly.
So, why it should be disturbed? Let it proceed.
Let it proceed.
If any outcome of the division bench is in their favor, they will get back that money for their sin.
Correct.
That is, it is not that something cannot be corrected.
Lordship.
Then
This true, Your Lordship.
why to complicate it in that way? You see?
That's all that we are saying. In case you are entitled,
I'll just place
if it
one
is found
judgment
they're
with your
entitled to
permission. There's only one judgment. I'll place it.
See, Mr. Sangresho, this court is not giving any finding at this one merit.
My
at
I'll
this
just,
stage.
my lord.
We are just on that application
Yes, yes.
on
yes.
the merits of that, and we are asking, we are directing for status quo.
My lord, I'll just point out the
That is,
conduct of the party, my lord. The Supreme Court 2024 itself, very clear. The Constitution is a land acquisition, non-adherence to Section 5. Supreme Court says that the Constitution do not contemplate, it says the Constitution does not contemplate acquisition by impose. Imposition. But this is exactly going on. Recollect,
Your contention.
my lord,
See,
this is exactly going on in this
very
very case, my lord.
This is a hard.
Look, just for my
Lordship may
satisfaction,
pass
just one last thing.
stay order
I
with
want to
regard to
order of
petition.
status-
I
Mr.
want to
we are asking order of status quo.
Lordship.
You just maintain the situation. What
Yes,
is
my
clear,
lord.
I think.
Just one thing, Lord. Because what's happened, I pointed out that applicant number 12 is actually not a party here. So there is a problem with the name of the party. This is going to create a serious confusion in the ground. Kindly see their affidavit for a moment. Affidavit, there are 86 people who are party to this case apparently. And he says he's been duly authorized. Where is the authority letter?
It is not
None of
required.
these
It
people
is not,
actually-
it
Is
is
it
a,
not that
we are
court
not
of the
appearing in the
writ
Munsif
petition?
court,
It
my
is
lord.
in the writ petition.
Exactly, exactly.
No, my lord. In the writ petition, Matthew M. Sangma was authorized.
No, no,
Today
no.
somebody else is
nothing,
coming before the court saying
nothing,
he's been
nothing.
authorized. Can you see the name of the parties? All different parties.
But-
How can authorities keep changing like this?
This submission can be
Is
raised
this not
before
a
the
valid
Munsif
point, my
court,
lord?
not the equity court.
In the
Anyway, this you raise this plea when this matter comes up day after tomorrow. We'll maintain status quo. Hard. We should understand for the applicants and also Mr. S. N. Leonard G. appearing for the state response and also Mr. Your
Number 15 and 16.
Mr. S. N. Leonard G. appearing with the state respondent number so and so, and Mr. R. Devnath. You have to say anything, Mr. Devnath. Anything you want to say,
Your Lordship, just
or you say it after tomorrow, because right now we are passing order of status. At least some protection there. You cannot just.
Your Lordship, here 39% already taken the compensation.
You raised it
Yeah.
on the other day also.
That-
Now that is, see, one thing what we will ensure is that whether how many of them have received compensation and how many have not, and if they have not received any compensation, and if thereafter we find that this dispute is only with regard to ROW, we will not entertain this petition. We cannot. This is because this will be totally covered by section 76 usage.
Lordship 76.
Because Your
Section
Lordship,
30 of the old act. I do
Yeah.
not know much about the new act, Mr. Shen. Yes.
here Your
Section
Lordship,
11 is old section 4, section 19 is old section 6.
Lordship.
Your Lordship, paragraph
Sorry,
10, they have mentioned
just
about
one.
it. The person who are taking the compensation in paragraph 10, they have already mentioned. They have taken the compensation, but they are still
All of
in the
them.
party.
Paragraph 10 of this application.
Yes, they have mentioned that they have received the compensation, but they are still in the party.
Twenty-six of them, Paratel.
Yes, that we have submitted. Yes. So and so, so and so. Then we just say, let's this matter, give the after tomorrow. Till then, status quo with regard to the plot of land in respect of status quo with regard to the plot of land of the applicants shall be maintained by both parties.
Keep your pledge.
This is the problem, Mr. Sangresh, is that actually thing is.
But let my friend come up.
This is,
Even receive
you see, like,
compensation.
it is how this court will go and you see determine the situation where you say that your structures are remaining. He says that your structure has been demolished, already removed. Now, which way this court will go?
But therefore, let
Think about that part about this POW. This
ROW.
probably this is the primary view of the court.
but I'll satisfy.
See, this is the
I'll satisfy.
this if something is covered by law and See, land acquisition matters, it has to be settled strictly in compliance with the provisions of the Act.
Yes, exactly, exactly.
If something falls outside the provision of the Act, okay, we may. But then if there is a provision to take care of that
Right,
situation,
right. I'll satisfy.
no way Great Court will.
My lord.
At least for this court.
Right, right. Main case lordship has 6 days after tomorrow, my lord. We expect the
Main
matter
case
will
is
be
coming
taken
up
up
day
for
after
hearing.
tomorrow.
Yes, for
We'll try to
initiation hearing.
finish it then. You see,
My
we'll
lord,
not
we'll
keep
finish
it
now.
this.
Okay.
Just come prepared then so that.
Yes, yes.
So this stay is
Good.
operating only
Please
till.
come with a list of the
Yes,
person
yes.
those who have women.
Lord.
Kindly prepare it and then.
I must
Make it
point out
ready
actually
to
they were
present, yeah.
preoccupied with this whole exercise. They
My
didn't
lord.
get a chance to prepare this entire list. But my learned senior has already indicated in para 10 the list of people who have already withdrawn the money. So for then he says bring the list again. They are well aware
And
of the
if
people
you get
who
in one piece of paper
Yes, well.
about all, then it becomes easy.
Yes, yes, well. But I'm just
Let
pointing out
them-
they were
let them file a
preoccupied
short
with this whole
affidavit.
exercise. That's the reason why they could not provide all the information. But I've taken instructions orally over the phone. This
We're
morning.
busy evicting the citizens. Doesn't have time to
Because of
prepare the
the-
record.
They've explained to me the problem actually. This entire fund is otherwise going to lapse. It'll go back. These are all foreign funding projects. Man. Meghalaya will not get these projects because of these. There are 3 or 4 cases because of which the entire acquisition process has been stalled for a very long time. And if this continues, we will lose these projects. We lose the entire fund.
No, you see, public work normally should not be. That is what the law is.
So if there's any issue with regard to the ROW, we are willing to settle it also.
Let them,
See,
my
there's
lord,
no problem.
See,
Let them-
see,
let them file a
Mr.
show
Sandesh,
cause.
if your claim is confined to monetary compensation, even if the project goes on, you can get your relief later.
I'll show.
That is one thing. And that should not be a reason for stopping development.
I'll show the after tomorrow. We expect matter will come preparation
See,
for final disposal.
at least one thing is clear. Just your claim is with regard to POW. Whether you are, according to you are entitled, according to him is not entitled. That is
I'll
what.
show. But the violation of the
So
procedure.
It means your relief is
My lord, the procedure violations. Lordship is correct.
whatever it is. What
Procedure-
relief
procedure
you, it is
violation.
procedure violation also.
So the
At
case may not
stage
become up.
where- See, there should not be any obstruction.
Exactly.
Why this order of keeping record has been made? So that you are not deprived of your.
Exactly, exactly.
So it doesn't seem, prima facie doesn't seem that court was impressed by the submission that there was some procedural. Rather, court was more with your claim for compensation, nothing else. That is why maintenance of record has been ordered so that your claim can be assessed properly.
Yes,
That is
exactly,
what-
exactly, madam. Let them file, my lord, may I suggest, let them file.
Definitely, that is
Yeah,
what
show
we'll see.
cause
But
day
then
after
we'll
tomorrow.
see, but then, see,
Bring
Mr.
on record.
Sandesh,
What compensation they have given, to how
see,
many outcomes.
so far is the area of land for which you are entitled to compensation. That falls under section 30. Oh, sorry, section
My lord, I'll
76.
satisfy, I'll satisfy, I'll satisfy.
Yes.
But I don't.
Yes.
Hello.